In Hangover Part 2, Stu Price wakes up after a wild night in Bangkok to find a tattoo covering the left side of his face. S. Victor Whitmill filed a claim against Warner Brothers Entertainment claiming copyright infringement on the tattoo he created for Mike Tyson. Does Whitmill have a claim? And what about Songify videos or Auto-Tune the News, and Pinterest and Tumblr? Don't they all violate copyright? Why can't we use whatever's on the internet? It's all public domain, isn't it? Hundreds of years ago, the only way to reproduce writings was with scribes. After printing presses sprung up, copyright laws were enacted to protect these books and writings. Today, copyright protects a number of works, including literary works, musical and sound works, artistic and video works, architectural and software works. Copyright does not protect ideas and facts, names, titles, and slogans, works created by the U.S. federal government. Although names, slogans, and titles are generally not protected by copyright, they may be trademarked, restricting their use. The letters TM accompany a trademark and require users to comply with their restrictions. Copyright gives the owner all rights to the material. Buyers of a copyright product, such as a book or video, own the product but not the contents. Buyers cannot use the product outside its intended use, such as redistributing, performing, displaying, or changing it. Since 1978, the author automatically has copyright protection from the moment the work is written or recorded until 70 years after the author's death. At that point, the work becomes part of the public domain or freely available for public use. Mark Twain's The Adventures of Huckleberry Finn and Scott Joplin's The Entertainer, heard in the background, are public domain works. People may apply a public copyright license to their work, allowing others to use it for their own purposes so long as the user complies with limitations, if any. Types of public licenses include open source software and Creative Commons, among others. Creative Commons licenses vary from giving credit or attribution to no commercial or derivative use. The law recognizes a fair use rule, allowing others to use a work without permission for the purpose of commentary and criticism, news reporting, research or education, and parody. For example, Barack's dubs are likely protected by the fair use rule. To determine whether use is fair use, courts look at a number of factors, including whether the user financially benefited from its use of the work. A number of court rulings and practices illustrate the evolution of copyright protection in the digital age. Early this century, Napster created a music utopia for enthusiasts everywhere. 80 million people were sharing music on their computers for free. But it all came crashing down when the Recording Industry Association of America sued for copyright infringement for $20 billion, bringing an end to Napster as it was. The RIAA even tried to sue individual users in exerting its rights to the works of the recording artists. In 2007, Viacom filed a lawsuit against YouTube claiming copyright infringement by illegally hosting videos from shows such as MTV and South Park. YouTube argued they were protected by the safe harbor provision of the Digital Millennium Copyright Act, a 1998 law that limits the liability of companies if they remove content when notified of possible copyright violations. In April 2013, a court agreed with YouTube, concurring that the DMCA protected them. Viacom has appealed the ruling. In compliance with DMCA, Google's transparency report indicates it removes around 1 million links monthly because of copyright infringement claims. In conclusion, the Internet is not public domain. In fact, almost everything found on it has copyright or other legal protection preventing duplication or derivative works. As for social media, including Tumblr and Pinterest, they comply with DMCA and issue takedown notices to minimize copyright liability. In the Hangover Part 2 lawsuit, Warner Brothers claimed fair use as the tattoo was a parody. There was not a judgment on the claim, however, because the parties settled. Songify videos and auto-tune the news likely fall under the fair use exception too. They are entertainment. The nature of the work has been transformed from news or interviews to songs. The portion of video is a small part of the whole, and the effect on the original video was probably positive, bringing it popularity that it would never have otherwise had. And as a practical matter, if the copyright owner benefits from the exposure, the chances of getting a takedown notice or sued are likely slim, although it certainly could happen. Thank you for watching.